Well, good afternoon, everyone, and welcome to this Guildford Chambers webinar. My name is Laura Smallwood. I'm a barrister specialising in landlord and tenant and property law at Guildford Chambers. The webinar will last approximately 40 minutes. If you have any questions about the material covered, please email me and I will respond. My email will be on the concluding slide. This webinar aims to provide a recap on the law and practice relating to forfeiture for leases for non-payment of rent. For 2 years from March 2020, Section 82 of the Coronavirus Act 2020 imposed a moratorium on forfeiture of relevant business leases for non-payment of rent. Although it remained possible to forfeit a residential lease for rent arrears, forfeiture is more often encountered in a commercial context. As of 25th of March this year, however, the relevant period ended, so this seemed a good time to refresh memories and review forfeiture for non-payment of rent. Forfeiture is a big topic, and in 40 minutes it's not possible for me to do more than give an overview, but I'm proposing to cover when forfeiture is available, waiver of forfeiture, how to forfeit, the effect of forfeiture, and relief from forfeiture. Some of the content will apply equally to forfeiture for other breaches of covenant, but my focus will be on non-payment of rent. To start with then, a working definition of forfeiture, and this comes courtesy of Lord Justice Fox in the Clays Lane case, where he defined forfeiture as a right to determine a lease by a landlord if A, when exercised, it operates to bring the lease to an end earlier than it would naturally terminate, and B, it is exercisable in the event of some default by the tenant. Forfeiture is the nuclear option in the landlord's arsenal. It provides the ultimate sanction of ending the lease and derivative interests. The draconian nature of this remedy means that the law leans against forfeiture, and so a host of rules and restrictions on forfeiture has developed under common law and more recently statute, and those in large part take up the rest of this webinar. The right to forfeit most commonly derives from an express proviso for re-entry in a lease. The landlord is entitled to treat the lease as forfeit on the occurrence of specified events, in our case the rent being in arrears and unpaid for a specified period. Otherwise, the landlord has no right to forfeit for breach by the tenant of any term in the lease unless it can be construed as a condition. A lease may therefore contain an express condition, and this would be phrased with words such as provided always that, or it is a condition of this lease that. Now, for completeness, I've also mentioned the third route into forfeiture on the slide, namely denial of the landlord's title, which is an implied condition in a lease. However, this very rarely comes up, and in any event, it is not relevant to non-payment of rent. The effect of a right to forfeit arising is that the lease is voidable at the landlord's election, not void. But once that election is made, it is irrevocable. Forfeiture is a one-way street. As for breach by non-payment of rent, the usual form of forfeiture clause for arrears of rent will provide only for forfeiture once a specified number of days, commonly 14 or 21, has elapsed after the due date for payment. The landlord can only forfeit once this grace period has passed. In many leases, rent is defined to mean not only the periodical payment by the tenant for exclusive possession of the property, but also other sums which are expressly reserved as rent by the lease, most commonly service charges or insurance. The common law requires that a formal demand for rent is made before forfeiture is exercised. It is important to check that the forfeiture clause in the lease you are looking at includes the phrase rent whether formally demanded or not, because this means that the formal demand can be dispensed with. Otherwise, subject to one statutory exception, the landlord must comply with archaic rules for a formal demand, which are contained in a series of Tudor authorities. And these include making the demand on the land itself on the last day for payment, before sunset, and then continuing until sunset. So you can see that there are obvious benefits of the demand being dispensed with. The exception to needing to make a formal demand is if Section 210 of the Common Law Procedure Act 1852 applies. That is where the landlord has a right to enter for non-payment. The rent is at least half a year in arrears, and either CRA, commercial rent arrears recovery, is not available, or there are insufficient goods on the premises to enable CRA to be used. Note that although no Section 146 notice is required to be served for a breach by non-payment of rent, this does not apply to service charges reserved as rent under residential leases. This is the result of the uncomfortable decision of the Court of Appeal in Freeholders of 69 Marina and Oran. That decision was the right result on one level, in that defaulting tenants were able to be held liable for the costs of preparation of a Section 146 notice, but unfortunately it was not justifiable in law. However, as a Court of Appeal authority, it remains binding, and so in this situation, a Section 146 notice must be served. Next, I would like to look at the restrictions on forfeiture which you need to have on your radar, which are likely to arise in the context of forfeiture for non-payment of rent. There are quite a few of them, but I'm only going to deal with 3 in any detail. Firstly, the Commercial Rent Coronavirus Act 2022. Now, although the Section 82 moratorium has ended, this does not mean that landlords can now forfeit for non-payment of commercial arrears accrued during the pandemic period. The 2022 Act, which came into force on the 24th of March 2022, ring-fences protected rent debt. This means rent, service charges, interest and VAT due under a Part 2 1954 Act tenancy, provided the whole or part of the business was required to close and the arrears are attributable to the protected period. This is defined as from the 21st of March 2020 to the earlier of the last date when closure of the business was required, or the 18th of July of last year. The moratorium under the Act will end on the 24th of September 2022, subject to government extension potentially, or the date on which an arbitration under the Act concludes. At that point, the normal situation will resume for unresolved pandemic arrears, and forfeiture will be available again. Section 6 of the Criminal Law Act 1977 looms large for its repercussions for forfeiture for peaceable re-entry. It is an offence to use or threaten violence for the purpose of securing entry into any premises if the person doing so knows that there is someone present who opposes entry. Violence is violence against a person or property, and the penalty is up to 6 months imprisonment. Section 2 of the Protection from Eviction Act 1977 prohibits peaceable re-entry of premises let as a dwelling if anyone is lawfully residing in the premises. In the case of Parabakaran and Patel, it was held that let as a dwelling means wholly or partly as a dwelling. And so this means that the provision applies to mixed user premises. Now, the net effect of the last 2 provisions is to restrict peaceable re-entry in practical terms to commercial premises out of business hours. I should also draw attention to statutory restrictions which are particularly relevant to a non-payment scenario. Section 81 of the Housing Act 1996 restricts forfeiture of a dwelling for failure to pay service charges, and by Section 167 of the Common Hold and Leasehold Reform Act 2002, there is a restriction on forfeiture for failure to pay a small amount, currently £350, under a long lease of a dwelling. I've mentioned on the slide tenancies under the Rent Act 1977, Housing Act 1985 and Housing Act 1988 as a reminder that in the case of a fixed term tenancy where those statutes apply, forfeiture is a gateway. The landlord must then satisfy the further requirements of the particular statutory code in order to obtain possession on the grounds of rent arrears. Finally, do be aware that in relation to certain insolvency situations, leave of the court is required in order to forfeit. And so on to waiver of forfeiture. This was aptly described by Mr. Justice Sachs in Siegel Securities and Thosby as a minefield. In essence, when a right to forfeit arises, the landlord has the option either to act upon it and terminate the lease or to treat it as continuing. If he does the latter, the right to forfeit is waived and lost. There are three ingredients to waiver, which were set out by the Court of Appeal in Cornilly and Saha, expanding on the classic statement of waiver in my namesake case of Matthews and Smallwood. They are, firstly, knowledge by the landlord of the circumstances giving rise to the right to forfeit, unequivocal recognition of the continued existence of the lease, and communication of the waiver to the tenant. I will elaborate on each element, but note that the burden of proving waiver is on the tenant, and non-payment of rent is a once and for all breach. So once it has been waived, the landlord cannot rely on forfeiture, in respect of that particular payment. Looking then at the three elements of forfeiture, knowledge is knowledge of the basic facts giving rise to the right to forfeit, so that knowledge of the legal ramifications of those facts is irrelevant. It may be express, constructive, or imputed. Express knowledge needs no elaboration, but constructive knowledge will apply where the landlord is suspicious and is on notice as to the possibility of breach. The extent of inquiries required by the landlord will depend on the particular facts of the case, but he cannot bury his head in the sand to avoid a waiver. Knowledge of the landlord's employees and agents may be imputed to a landlord, depending on the nature and extent of the authority of the persons concerned. In the Metropolitan Properties Company Limited and Cordery case, a porter's knowledge of the subletting was imputed to a large corporate landlord because of the nature of his authority. The second element of waiver is unequivocal recognition that the lease subsists. What is required was described in Expert Clothing Service Sales Limited and Hillgate House Limited as conduct so unequivocal that when considered objectively, it could only be regarded as having been done consistently with the continued existence of a tenancy. So, in other words, if there is scope for some other interpretation of the landlord's conduct, the consequence of waiver can be avoided. The objective assessment is carried out by looking at all the circumstances and means that the landlord's intentional motive for his conduct are irrelevant. For example, in Central Estates, Belgravia Limited and Woolgar No. 2, a clerk mistakenly demanded and accepted rent, but it was held to be a waiver. Against that general background, I want to home in on waiver related to rent. A distinction is drawn in law between situations where the legal effect is a clear waiver and there's an automatic waiver, and other cases where the court looks at all the circumstances to consider whether the act relied upon has the necessary unequivocal character to be considered a waiver. Acceptance of rent has special status in the law of waiver. Since Tudor times, it has been the case that acceptance of rent with knowledge of a breach will waive the right to forfeit. To be a waiver, there must be acceptance of rent falling due after the right to forfeit has arisen. And also, only clarified last year by the Court of Appeal in the case of Fives and Burnley Borough Council, there will be a waiver if, with knowledge of the breach, the landlord accepts rent falling due after the breach, even if on the date when the rent fell due, he did not know about the breach. Checks should be returned in order to avoid waiver. It's going to be difficult for a tenant to demonstrate acceptance of rent if a cheque has not been banked. But if it is banked accidentally, processing of the cheque is not conclusive of the payment being accepted as rent. In Seahive Investments Limited and Osibanjo, the tenant sent a £10,000 cheque partly for arrears and partly to settle a bankruptcy debt. The landlord processed the cheque and then kept the bankruptcy amount but returned the arrears. The Court of Appeal said that processing was evidence of the payment, but for a waiver it had to be shown that the payment had been accepted by the landlord as rent, and it had not. Automated payments, of course, are very common today, but it has been held that there is no waiver where rent has been received electronically but repaid as quickly as the circumstances permit, and that is what happened in the case of John Lewis Properties plc and Viscount Chelsea. Beware accepting rent without prejudice. In Wimble Investments Limited and Milano Restaurant Limited, there was an acceptance of rent expressly without prejudice to the tenant's breach of covenant against parting with possession, but that was held to be a waiver. The court held that once it was decided as a fact that money was tendered and accepted as rent, the question of its consequences as waiver was a matter of law. And graphically, Mr. Justice Sachs in Seagull Securities said that the law treats rent as a piece of cake equivalent to the land from which it derives. He said its nutritional qualities in the landlord's hands are unaffected by attaching the label without prejudice. I should briefly mention appropriation in the context of acceptance of rent. A tenant can expressly or impliedly appropriate a payment to the debt of his choice. The landlord must then apply it as required by the tenant or return it. If the tenant does not appropriate the payment, the right devolves to the landlord and he can elect to apply it as he wishes. However, he must communicate that election to the tenant. If there are historical arrears, therefore, this means the landlord can communicate his appropriation of a payment to those sums and so avoid a waiver of the right to forfeit in respect of a more recent payment. A demand for rent has widely and for a long time been considered to be on a par with acceptance of rent, i.e. it is an automatic waiver. Lord Justice Newburgh, as he then was in the Thomas and Ken Thomas case, stated obiter that this is a classic way to waive the right to forfeit. However, it is the case that this point has not been decided by a higher court. So, for example, in the Greenwood Reversions case, the tenant argued that demand equals waiver, but the Court of Appeal found that on the facts it did not need to decide the point and expressly left it open. Exercise of CRA, commercial rent arrears recovery, is also an automatic waiver. The authority for that is the Bra case, where a purported forfeiture by a landlord was held to be unlawful because the landlord had previously exercised CRA. However, the landlord will have a defence to a tenant's claim of waiver if Section 210 of the 1852 Act applies. This is because one of the conditions for that section to operate is that CRA has been attempted, and so there is a let out for a landlord in that situation. So other conduct amounting to waiver, which is rent related, these are examples outside the special category of demand and acceptance of rent. So they illustrate the principle that there is no plausible explanation of the landlord's conduct, but that he is treating the lease as subsisting. Serving proceedings claiming rent arrears without an accompanying claim for forfeiture will be a waiver of the right to forfeit for the rent claimed, as will demand for a service charge reserved as rent. Perhaps that's not surprising in the light of my previous comments. Then a couple of examples of rent-related conduct not amounting to waiver. A demand for insurance or service charge not reserved as rent. This, of course, is the flip side of a demand reserved as rent. In the Yorkshire Metropolitan Properties case, the landlord had refused rent and also served a Section 146 notice. A subsequent demand for an insurance payment, which wasn't reserved as rent, was held not to be a waiver, and Obiter, Mr. Justice Newberger, as he then was, suggested, not surprisingly perhaps, that a service charge demand, which was not reserved as rent, would be treated the same way. Payment of rent by a guarantor is a contractual obligation. It is independent of and not subject to the subsistence of the lease, and therefore the discharge of rent by a guarantor is not waiver. The final element of waiver is communication to the tenant. And where the conduct relied on is the sending of a document, this means that it is only effective when the document is received. So if, as in the case of trustees of Henry Smith's Charity and Wilson, a demand for rent is sent but not delivered to the tenant, there will be no waiver. Having considered all those preliminaries, how should the landlord effect forfeiture? The options being either peaceable re-entry or action. It's worth saying that just because forfeiture is available doesn't necessarily mean that it is the right remedy, especially in a depressed market where the landlord will be left with an empty property perhaps and the liability for business rates. It may be a better option to sue for the arrears, look to the rent deposit or the guarantor. As a headline on this slide, I have reproduced a dictum of the House of Lords in Bilson and Residential Apartments, where it was said that peaceable re-entry is a dubious and dangerous method of determining the lease. That is true because on the basis of the Criminal Law Act 1977 and the criminal sanction, it is a potentially hazardous option. However, it remains a standard method of forfeiting a commercial lease because it is straightforward, fast and low cost. What is required for a peaceable re-entry? Well, primarily an unequivocal act. The classic method, of course, is to change the locks, or equally one could change the key code or padlock an entry. What counts as an unequivocal act will very much depend on the nature of the land concerned. For example, in the case of farmland, it might be a situation where concrete barriers are put at a farm gate, or if it is simply open land, a chain is erected across it. Usually, a forfeiture clause will state that the landlord may enter part in the name of the whole of the land, and that does simplify the practicalities of a peaceable re-entry. An intention to forfeit is obviously required. This can usually be presumed in the case where locks are changed, but not if the landlord's motivation is otherwise. In Relvock Properties and Dixon, the landlord changed the locks for security reasons because the tenant had absconded, and not surprisingly there it was held that there was no forfeiture because the landlord had no intention to elect to forfeit. A notice put up at the premises confirming that the landlord has forfeited will clarify any uncertainty, however. Finally, the forfeiture again must be communicated to the tenant. The act of re-entry can make this implicit, but it is sensible to put up a notice to that effect. The alternative is to forfeit by action. And this is effected by the service of the proceedings because that amounts to a notional re-entry. Service should be effected on the tenant for the time being. Therefore, if there has been an unlawful assignment, you must serve the proceedings on the unlawful assignee. But if there is an incomplete assignment which has not been registered, it is the assignor who is the tenant for the time being. An unequivocal act is again required, and of course seeking possession is unequivocal. But beware claiming additional or alternative remedies which may muddy the waters on the landlord's election. In Moore and Ulcoats Mining Company Limited, the landlord claimed possession and also an order for inspection of the mine. It was held that these claims were inconsistent, and so the writ was not an unequivocal demand for possession so as to operate as a final election to terminate the lease. The proper forum for a claim for forfeiture will overwhelmingly be the county court. CPR 55 and the associated practice direction make clear that claims should only be brought in the High Court in exceptional circumstances. As for the effect of forfeiture, well, on peaceable re-entry, there will be an immediate termination of the lease, subject though to any application for relief. Derivative interests also terminate, as does all liability, whether of the tenants, assignors, guarantors, whatever, in respect of future breaches. The tenant's fixtures will revert to the landlord on a peaceable re-entry, and the tenant has no right to remove them. And finally, the landlord cannot use CRA, and that includes for rent accrued prior to the forfeiture. The effect of forfeiture by action is not so straightforward. Woodfall describes it as obscure. This is because although the service of the proceedings is a notional re-entry, the lease is not terminated and the tenant's covenants extinguished until judgment for possession is given. When the order for possession is eventually made, it will relate back to the date of service of the claim form, and all derivative interests will terminate with the lease on the judgment for possession. So the period between service of the proceedings and judgment, and also continuing while there is any application for relief, has been described as a twilight period. In this period, because the landlord has elected to forfeit, he cannot enforce the covenants in the lease, for example, by an injunction or by claiming damages for a breach occurring after the service of the proceedings. By contrast, the tenant can rely on and enforce the covenants in the lease, for example, by injunction. In the Peninsula case, a tenant obtained an interlocutory injunction to compel the landlord to put a lift in working order during the pendency of proceedings. A tenant is no longer bound to pay rent in this period, but if he continues in possession, he will be liable for mean profits until possession is given up. Relief from forfeiture for non-payment of rent. Forfeiture for non-payment has always been regarded as a security for the rent. This was the case when the relief depended on the equitable jurisdiction of the court before the various statutory provisions which now also come into play. The principle, therefore, is that if the landlord can be put back in the same position as if the covenant had not been broken, the tenant will obtain relief. And in the context of non-payment of rent, this means, of course, payment of the arrears and expenses. Relief is available for termination of leases, but also be aware that it can apply to possessory licenses on the basis of the Supreme Court decision in the Manchester Ship Canal case. Who can apply for relief? Well, the tenant, but also an underlessee or mortgagee. And how to seek relief? Well, either by counterclaim or by application using CPR 23 in the landlord's proceedings, or by making a freestanding claim for relief. The rules governing relief depend on the method of forfeiture, the forum, and the stage at which relief is sought. Invariably, however, relief will be in a county court situation. By action in the county court, the equitable jurisdiction has been put on a statutory footing by sections 138 and 139 of the County Courts Act 1984. Prior to execution, there will be automatic relief if the tenant pays all the rent in arrear and costs into court not less than 5 days before the hearing. On that basis, the landlord's action automatically ceases. If the claim progresses to a hearing and an order for possession is made, it must specify not less than 4 weeks from the date of the order for the possession order to take effect. If in that time the tenant pays, then again there is automatic relief. That is by virtue of section 138(3). After execution, then section 138(9)(a) gives the court jurisdiction to grant relief for up to 6 months on such terms and conditions as it thinks fit. The 6 months, however, is a long stop, and thereafter by section 138(7), the tenant is barred from all relief. In relation to relief in the county court after peaceable re-entry, the tenant can apply under section 139(2) within 6 months of the date on which the landlord recovers possession. And the court may, if it thinks fit, grant such relief as the High Court could have granted. But there is again a 6 months long stop. As I have said, in the High Court, applications for relief will be rare. But the situation is underpinned by section 38 of the Senior Courts Act 1981, which effectively restates the court's equitable jurisdiction to grant relief for non-payment of rent. In the case of forfeiture by action before execution, then section 212 of the Common Law Procedure Act 1852 provides automatic relief where at least 6 months' rent is in arrears, if the tenant pays all the arrears and costs either to the landlord or into court before trial. If there is less than 6 months of arrears, then the equitable jurisdiction to grant relief applies. After execution, the tenant is entitled to discretionary relief if all arrears and costs are paid within 6 months of execution. This is where there are at least 6 months of arrears. But after 6 months, the tenant is barred from all relief. In other cases, i.e. where there is less than 6 months arrears, then one is looking at the equitable jurisdiction. This follows the law, and so the 6-month limit will again be the guideline. In relation to relief where there has been peaceable re-entry in the High Court, it is entirely discretionary based on the equitable jurisdiction of the court, so relief on such terms as the court sees fit. I thought it would be useful to briefly look at how the court will exercise the discretion to grant relief. I've referred on the slide to the case of Keshwala and Balsod. This related to the exercise of the discretion where a landlord had peaceably re-entered and the tenant sought relief just within the 6-month window allowed for in section 139(2) of the 1984 Act. On the facts there, the court refused to exercise the discretion to grant relief. The judgment of the Court of Appeal, though, is worth reading for the explanation of the jurisdiction and discretion to grant relief. Lord Justice Nugee, in the case of Keshwala and Balsod, stated the general rule that discretion to grant relief is exercised in the light of that principle that equity regards the right of re-entry as security for payment of rent, and so other things being equal, the court will ordinarily grant relief if the tenant pays all that is due. And further, Lord Justice Nugee endorsed earlier authority that in exercising the discretion, generally breaches of other covenants will be irrelevant unless they relate to the tenant's conduct. Now, the mere fact of delay is unlikely to affect the exercise of the discretion, but it will be a factor if either as a result of the passage of time the landlord has altered his position, or the rights of third parties have intervened, so that relief will defeat the rights of third parties, or it would be unfair to the landlord to grant relief. An obvious example is the grant of a tenancy by the landlord to a third party, and this is what actually happened in the Keshwala case. In relation to the exercise of the High Court discretion beyond 6 months, the issue of the tenant needing to act with reasonable promptitude has been discussed in various authorities. Now, time today doesn't permit me to go into this, but in the case of Keshwala, Lord Justice Newgee said that there is no principle that a tenant who acts within 6 months will be deemed to have acted with reasonable promptitude. So from that, take away a message that tenants should seek relief as soon as possible. In the exercise of the discretion, the court must order a period for payment of arrears. In Intrapreneur Pubco plc and Langdon, Mrs. Justice Arden said that this should be within the immediately foreseeable future, so that the court can say with a sufficient degree of certainty that the rent will be paid. And by way of illustration, in Ayala and Newham London Borough Council, there was no reasonable prospect of the tenant paying the arrears in under 24 months, and on that basis, relief was refused. What must be done for relief to be granted? Well, as far as payment of the rent, this might seem obvious, where section 138(3) of the County Courts Act specifies payment of all the rent in arrear, and section 212 of the Common Law Procedure Act states all the rent and arrears. But the Court of Appeal in Thomas and Ken Thomas, albeit that this was obiter, stated that those phrases mean all the arrears in respect of which the landlord could rely to effect a forfeiture. In other words, the tenant should not be required as a condition of relief to pay any sum for which the right to forfeit has been waived. Therefore, it seems that in a situation where there are arrears over a period of time and the lease has been forfeited for non-payment of a later rental period, which has implicitly waived the right to forfeit for older arrears, a tenant could assert that the payment of the earlier arrears should not be a condition of relief. Now, I have already touched on the remedying of other breaches of covenant, but I should briefly consider costs on relief. Putting the landlord back in his previous position as if no breach had occurred will mean that the tenant is required to pay the landlord's costs of the forfeiture action and the application for relief. As a general rule, as was restated in Patel and K&J restaurants, indemnity costs will apply, but this will be subject to the court's discretion in relation to costs. In Bland and Ingram Estate Limited, a landlord unnecessarily opposed the granting of relief and so was ordered to pay the tenant's costs of relief on the standard basis. The effect of relief in the case of the tenant is the reinstatement of the original lease. And in the case of third parties, i.e. subtenant or a mortgagee, then in summary, either a new lease or sometimes reinstatement of the original lease will occur, depending on the route to relief used. Finally, remember that a court order for relief is necessary. The parties cannot agree to grant relief. The landlord has irrevocably elected to forfeit, and there is no going back on that. Also, the power to grant relief lies in the equitable jurisdiction of the court, although that is now partly on a statutory footing, and the parties cannot bypass that. If the parties agree relief, it will amount to the granting of a new lease, not the reinstatement of the old one. And that can have far-reaching ramifications if, for example, the forfeited lease was contracted out of the 1954 Act. In Zestcrest Limited and County Hall Green Ventures, which is a county court case but nonetheless useful to know, the parties had agreed that relief should be granted, but the tenant had argued that the landlord was being unreasonable in requiring a court application. The court held that the landlord was entitled to indemnity costs of the formal application for relief against the tenant. It was not unreasonable for the landlord to insist on an application to court where the agreement would entail a new tenancy being granted and so prejudice to the landlord. The order can, of course, be a consent order, but do ensure that the grant of relief is in the order itself and not, say, in a schedule in the case of a Tomlin order. As I said at the outset, this webinar has necessarily been an overview, but hopefully it has dusted off the topic of forfeiture for non-payment of rent, now that it is once again a usable remedy for commercial landlords. If you have questions on the material I have covered, do contact me by email at the address on the slide. The slides will be sent out to all attendees, and this webinar will also be available to view on the Guildford Chambers YouTube channel. Thank you very much for attending, and good afternoon.